Welcome to StarTalks powered by Advotalks. Today, we have with us our most esteemed guest, Counsel Ayaz Mehdi. Mr. Ayaz has a vast experience as a seasoned lawyer practicing in family, criminal, estate, and civil litigation matters. With a profound understanding of the legal landscape both locally and internationally, Counsel Ayaz stands out as a reliable guide for individuals navigating the challenges of successful litigation. His expertise lies in providing comprehensive counsel to clients grappling with family, civil, or criminal matters, whether it's a contested divorce, the defense against a civil claim, or a criminal trial. He is dedicated to navigating his clients through the intricate maze of the legal system. His primary goal is to ensure that their interests are not only protected but a fair and just outcome is achieved. He is committed to being more than just a lawyer. He is a trusted barrister and an advisor. Today, he has joined us in StarTalks to express his views on family laws in Canada, the provisions for divorce, concepts like will, and other aspects like estate planning. I should admit that I am quite excited to host him. With that, I warmly welcome Mr. Ayaz Mehdi to our talk show, StarTalks, powered by Advotalks.
Thank you, Siraj. Good morning. I believe it's a good morning here. It's probably good night for you there. Thank you, Advotalks, for having me here as a guest speaker today. I'm excited to join you guys, and hopefully I can help you out navigating some of the topics that you've just mentioned, barring some time, but we'll go from there.
Yes, thanks for joining, sir. So this is going to be pretty much exciting and insightful, as I believe. And let me start this with some fundamental, understanding that we look from you. So can you introduce a bit of the family law in Canada, various provisions, and especially a little bit about the divorce aspects as well?
Sure. So that's a very loaded question. I'll make it very clear. There's no brief explanation of the vast area of family law practice, but certainly it comes under civil procedure, but it is itself a different area of practice. Surely in Canada, family law comes from common law, imported from England, well, hundreds of years ago. There are some changes, I'm sure, but generally the idea is it's a no-fault divorce country. When I say no fault, that means that, there is essentially nothing, no party gets punished when it comes to exercising their rights at separation, even if they're the one who initiated the separation. There are three grounds for divorce in Canada: adultery, cruelty, and separation. Separation is the one that is used, I would say, 99.9% of the time. Adultery and cruelty are there too, very rarely used. I would never recommend anyone to use those grounds because the difference between adultery, cruelty, and separation is the time it takes for the court to grant you divorce. Generally, separation means 1 year of separation, and then you can the court can legally grant you divorce, whereas cruelty and adultery, if you're able to prove it, the court can grant you divorce right away. Given the timelines in court, a year would pass way before you are at that stage where the court can grant you divorce. So generally, the recommendation is to stay from those two grounds of divorce. But that's, that to give you a bit of a brief overview. The other thing is we have equalization. Generally, the idea that you must have heard, well, if you watch any Western movies, you must have heard that everything is 50-50. That essentially, well, there are some nuances in there too, but generally the idea is everything that you guys create, even if it's one party that pays for everything, everything that has been gained in the family throughout the marriage is owned 50% by the other party, whether they're on title of that thing or not. So those are the general ideas. I will say this much though, that in Canada, and I would hope in all countries, Divorce Act and Family Law Acts, provincial, they all revolve around the best interest of the children. Children are the main focus of any separation, given that there are children in the separation. If they're not, then we can all agree that, there are only two contested issues in any separation: the children and the money. Those are generally where we are. So, Siraj, if there's anything else specific I can tell you, let me know.
Yeah,
Generally,
definitely.
that's a brief overview.
Yeah, I think like you have opened the conversation, for multiple touch points, like especially on the aspects of the no fault, as well as the grounds for the applying for the divorce, as well as you mentioned about the children welfare. So let's take a kind of step back and then try to understand more aspects on the grounds that you have mentioned, and also you have definitely mentioned about the no fault divorce. I guess like it is pretty much limited to some of the constitutions across the globe. So we wanted to know more about these aspects, I guess.
Sure. So I'm not too familiar about how family law works in India itself, but I think I know enough about it because I've done quite a bit of cross-border litigation, especially when it comes to children. My understanding is that India itself is not a signatory to the Hague Convention on Abduction of Children. So that's a huge issue, especially if couples, one of the parties is an Indian and wants to take the children to India. That's one thing that we fight generally because my understanding is India as a country generally says that even if the parties are not non-resident of India, they can still apply for a divorce in India. So that's one of the reasons, one of the things that have come up generally in my practice where we try to make sure that the children do not leave for India because it essentially becomes impossible for them to be brought back to Canada, even if they're Canadian citizens, because if they have dual nationality, that's a problem. Now, you said grounds of divorce. I'll give you some basics of what you need, especially in Ontario. So I practice in Ontario. So in Ontario, you need to be a resident of Ontario for at least 1 year before you can apply to the courts for divorce. So let's say if you moved here from somewhere, you need to wait for at least a year to meet the residency requirements. It doesn't matter whether you're a Canadian citizen. Your immigration status has no bearing on it. It's only the time of being here. If you've been here for a year, you can apply for it. Both parties don't need to be here. Only one has to be here. Um, we have certain ways to serve people outside jurisdiction. So again, that's that. Courts in Ontario will accept jurisdiction, especially if the children are in Ontario. If the children are not in Ontario and they were never a habitual resident of Ontario, then the courts may accept jurisdiction, but you may have a hard time really convincing them to do anything, especially if the other parties are in a different jurisdiction in Canada or US. Generally, it's easier for us to have our court orders enforced if the parties are still in the continental North America, I would say. Now, when it comes to the waiting time, the grounds, we had discussed it a little bit, so I'll just go into a bit of detail. So there was a time, so you have to understand, in Canada, I'm sure like many other Western countries, divorce has nothing to do with religion. Religion plays no part in divorce law. Although, given that there are certain religious institutions or religious customs that do play a part, let's say for Muslims or Hindus or Christians. Well, in Canada, that has nothing to do with you can do whatever you want in your religious way. The courts still go by what the law is.
Yeah, this is quite different from what we have as family laws, back at home in India.
Especially for
Like we have.
Muslims, I know. I
Yes,
know.
so we have the personal law, and then there is a difference between how it works for the Hindus as well as Christians. And yeah, thanks for bringing that point. The difference in
So
the.
I'll explain it to you. So you have to understand when you really look into, I guess, religion, and I don't want to go in too much into it, but in under the Christian religion, there is no idea of divorce, right? So uh, what used to happen about 50, 60, 70 years ago in Canada, there was no legal way to divorce because, well, there was no divorce in Christianity. So what used to happen was that you actually had to make a petition to the Senate of Canada to get divorced. Now, again, like I said, because there's no divorce, there's no culture of divorce, people would get separated, but there was nothing, no legal well, I'm sure there were legal remedies available, they were just too expensive and time barring. So then eventually they came up with the Divorce Act and they were like, well, we can't just bring every divorce to the Senate. Let's do it this way. So over like you just mentioned, and I know from knowledge that in India, Muslims have a separate Sharia way of dealing with their divorces, whereas in Hindus may have a different way. Whereas in Canada, it doesn't matter what religion you are. And that brings an interesting question. In the Canadian Criminal Code, there's actually a crime for polygamy that says that if you're married to two people at the same time, that's a crime. But the Constitution is very clear. The Charter is very clear that you have freedom of religion. So Muslims, because in Islam you're allowed to have four wives at a time. That is essentially, it's never the polygamy section of the criminal code is rarely practiced in modern times and has never been practiced against Muslim people because they know that it won't stand the scrutiny of the charter if they charge someone like that. So uh, in Canada, the law considers the first wife the wife with all the rights and everything, and the wives after that are generally in the well, in the governmental system, they're not really considered anything. So you can't be sponsoring four wives. The court, like the immigration system, won't accept it, but the family law court will accept it. So it's, for example, you have two wives, and the second wife wants to go for a divorce, she may very well have a claim for everything, and the first may have the same claims. So that's an interesting part. And again, like I said, that goes into too much detail. We were talking about grounds. Grounds separation is the simplest ground, right? You don't actually have to do anything legal to show separation. You generally just say that, well, the day you say, I always sometimes to explain it to my clients, I say that, you could be married for 50 years and one morning get up and look at your spouse and say, you know what, I want a divorce. That itself is a good enough reason, a legal reason to get divorced. You don't need a reason. And that's it. And once you say that, it's been, communicated to the other party, whatever way it's done, as long as you can prove it that you wanted to live separate and apart, you could very well be living in the same house and separated. So, that's generally the easiest way to do it, the regular way to do it that I recommend. There is adultery, that's the simplest way. If you can prove that one spouse cheated on you, although they won't be punished for that, but you could get a earlier divorce. But again, by the time, I always tell my clients, I'm like, there's no reason for you to air your dirty laundry in open court. These are public records that are going to be there forever, especially if you have children. This is not smart. Even if you can prove that the other party is unfaithful, I'm like, what does that do? It's not going to get you more money. It's not going to get you the custody of the children. Why do you want to do that apart from the fact that you just want to antagonize the other party and perhaps make it good for me and the other lawyer so we can charge you? So and the last one is cruelty. Now, I have an understanding of it, and I'm sure maybe some practitioners may have a different understanding. Cruelty is not that you got into a fight and you got charged for domestic assault. That's not cruelty. Cruelty is to the level where you know you may have, I don't know if you've heard it, but we've had some cases in North America where a spouse kept the other spouse in the basement chained up for years. We're talking about that. That's cruelty. And again, the idea of trying to prove that, you are better off just saying we're separated and I want a divorce, wait for a year. It may take more than a year to resolve all other corollary issues anyways. So that's what I would say, that, from the perspective of grounds, Siraj, that's what I would focus on. Uh, Now, if you want to talk about, I would say the children, spousal and child support, I would start again, like I said earlier, Canadian Divorce Act and all family law legislations revolve around this one sentence, the best interest of the children.
Right.
This is paramount, and I would hope it is paramount in many other jurisdictions too, but it's just it in itself is a beast in Canada. Like if there's children involved, the focus must stay on them. And we have many government organizations that provide Office of the Children's Lawyers there. We have there's voice of the child reports that can be done to get the children's wishes, although courts are very clear that the children, especially children under 10 years old, do not get to decide what and where they go. They're too young for that. Whereas children who are over 10, 11, 12, 13, 14, the judges say that we do appreciate and we'd like to hear what their opinion is as well. I can tell you this from practice that when the children reach like 14 or 15 or 13, the judges are very clear that, look, I'm not going to force a 14-year-old to go see a parent if they don't want to. Like, what's the point of it if they don't want to do it, right? So again, there are nuances in it. Certainly children are the ones that are most affected when parents separate. There's alienation of children. Parties improperly get the children involved. It is a big no-no, but it happens. There are quite a lot of protections for children. Children do not come to court. I have actually never seen a child come to court until when, they're considered children until they're 18. Even adult children, the courts are quite against having the children involved into the litigation. Very rarely, in very rare instances, you can ask for a judicial interview of the child at the stage of a trial. We once I Last year in January, I had a 10-day trial where both counsels had agreed that we're going to request the judge for a judicial interview, but the judge can still deny it. That's number one. I was actually last couple of weeks ago, well, last week I was at a motion where there were abuse allegations against the father, and we had the Children Aid Society show up, their counsel showed up, the investigator showed up. We got an opportunity to question the investigator, and then there was this one point where the other party just wouldn't agree to, and the judge said that, look, um, although neither of you asked for it, I do have the ability to interview the child if that's what you want. And I kind of stopped the judge and said that, look, Your Honor, if you look at our reply affidavit, we actually requested it because we knew it may come down to that. And then, my client just nudged and said she doesn't want the child to go through it. So there's that opportunity to, you will hear from judges that when the judges are taking care of a matter, they're like, this child is under my care. I am going to focus on it. That is the most important thing. Now, that's the children issue. What we used to call, custody and access before, they have been now changed, amended recently, given the aggression and the fights that those two words bring. They've changed that custody to decision making and access to parenting time to just bring down the temperatures of people when they're essentially fighting for the children, considering them a property instead of children. Now that is this children aspect of it. So
So I was trying to ask you, like, how does the legal system actually determine the amount and duration of the support payments? That was something that I was trying to understand from you guys.
so yeah, that's what I was going to get to. So now support, there are two kinds of support. There's child support, very straightforward. And then there's spousal support, which I'm sure there's another word used for it, alimony. Same idea. So with child support, it's quite straightforward. Child support is owed to the parent who has primary care of the children. So, for example, if the child is with the father and lives with the father, and the mother sees the child maybe once or twice a week or something like that, then the mother must pay child support to the father, and the child support is decided on that person's income. So we look at the tax return from the year before, line 150. It's straightforward. It's not that you have to pay a specific amount. It's what you earn and you pay according to that. There's child support guidelines That's how we calculate the number. Now, that's a very simple understanding where, the child is living with one person. There are instances where the child is either spending, well, the idea is shared parenting is considered where the child spends up to 40% of the time with the other parent. Once you hit that 40% threshold, then it's considered shared parenting. If that's the case, in that case, again, it depends on both parties' income. If both parties earn, let's say, $10 a month, then there is no offset. They both earn the same amount of money. No one needs to pay anyone child support. But let's say, for example, one party earns $15 and the other earns $10, but they have shared parenting. Then the party that earns 15 has to pay child support on those same guidelines on those $5 extra that they earn, right? So it's simple like that. Whereas well, it's not simple, but I would say, I hope it was simple. It's not that simple generally in practice. Then there's child support, and then the other is it's called Section 7 expenses. Section 7 expenses are above and beyond child support. They deal with some specific expenses, and there are many things that can be considered Section 7. But to give you an understanding of Section 7 is, let's say your child has extracurricular activities, football, piano lessons, swimming, um, university fees, those are considered Section 7. And even Section 7, the percentage of those costs is apportioned according to what you earn. So if you earn, I'll give you an example of someone who earns, let's say, $20 and the other parent earns $10, then they have a specific percentage of what they should pay compared to the other parent. So those are the support scenarios for the children. Now, when it comes to spouses, there's duration. Before I end that, how long do you have to pay support? So generally, the idea is once the child turns 18, they're an adult. Well, that's not what it is in Canada. A child is considered a child of the marriage even after 18 if they're in full-time school. And we family lawyers generally agree that until they finish their first degree in university, which could be up to 21 years. But yes, after 18, the requirement to still get support is full-time education, to be enrolled in full-time education. Now, when it comes to spousal support, uh, there's duration, there's the responsibilities that the parties had during the marriage. There's compensatory, there's non-compensatory grounds. Uh, Compensatory could just very well be, I would say generally, the idea is that, a parent who's not employed during the marriage, the general idea is that they were the homemaker. And, in most scenarios, it would be the wife, but there are a lot of times when it's the husband as well. So there's uh, that part of it, because the idea is the court understands they gave up on a career to raise a family, so they must be compensated appropriately for that. Then there's an idea that that's the general idea that everyone follows. Now, again, that comes down to, let's say, what if both of them were working full time during the marriage, right? One would say that, well, then it's not the other side's fault that if they did not have the proper earning potential. Even in those scenarios, the court considers that, just because you were married to a partner, you had some advantages and you did better in your career. So let's say if one party doesn't work and the other works, of course, the idea is they owe support. Let's say if both parties were working, then they look at their income as to, let's say if one party was earning 100 and the other was earning 50, then they would be like, they need to be compensated for the extra income or the advancement in the other party's career in a sense that, is fair. So now, how it is calculated, there's spousal support guidelines that we go through. It's a very complex calculation. The child support calculation is very simple, whereas the spousal support calculation is very complex. And we generally use a software. Every lawyer may have, generally lawyers in Ontario would have DivorceMate, and they do the calculation for you. And what it does is it takes in parties. Well, there's other factors too, right? The length of the relationship is a very important factor. If the relationship is under 5 years, the idea that, you're gonna get a lot of support or any support is hard. But once you hit the threshold of 20 years, the idea is spousal support is perpetual. So there's also the rule of 65, which is your age plus the length of your relationship. If it hits 65, then it's perpetual. Then, so what this software does is it takes in your age, if you have children, if they're living with you, if you're paying child support, because child support is a priority before spousal support. Then it takes both of your incomes, it takes the length of your relationship, and then it spits out three amounts. One is low, one is mid, one is high. And it gives you an idea that, the spousal support should be between these ranges. And then you have to kind of make an argument to the court or come to an agreement what you should pay. Now, with spousal support, you have the ability to pay a lump sum, to say that, I want to pay it off today and be done with it. If you choose to pay lump sum, in which we generally recommend people to do it if they can afford it, it's a clean break. No one has to worry about it, because if you are paying monthly, well, there's good and bad things about it. Monthly is long, you're paying a higher amount, but at the end of the day, there is material change that you can use to stop paying. Material change could be you lost your job without any fault of your own. You're injured. There's 1,000 things. Another thing is, if you're paying monthly, the other party generally cannot get married, because they're kind of stuck with essentially taking support from you. If they get married, the idea that your ex should support you doesn't really make sense. I actually, very very early on in my career, I actually dealt with a case that dealt with this specific issue, where husband and wife separated after 16 years of marriage, quite a long marriage, and husband was, ordered to pay a specific amount of monthly child support, which he was paying. 3 years after separation, he realized that she's a Muslim, right? So what she did was she did a religious marriage. So she just did the nikah, but she never registered it anywhere, because they're both residents of Ontario. She didn't have to. She didn't do it on purpose. So she knew that if she did that, she may lose her support. Now, everyone knew about it. This guy was living at her place, and she was just like, she's not going to do it, and he's going to keep on paying. So this guy was very smart, actually. Very early on in my career, there's so much I learned from this case. So this guy, what he did was he hired a private investigator to essentially, get all the information that he needed to show that they're in a permanent relationship, not marriage. The marriage, he only had one proof, where his ex's mom passed away, and they sent out an email essentially saying that, oh, you know, they named the new guy as the son-in-law in the condolence email, right? So he sent me all of that. I told him, I was like, she's never going to admit that she's married. How do we prove that, right? He's like, well, let's try. So I wrote to this lady essentially saying that we know you're married and you need to stop doing this. We're making you an offer. If you stop today, we won't try to claw back the 2 years of support that you've gotten while you were married. So this lady, I don't know what happened. She responded without any advice. She said that I'm not legally married in Ontario. I was like, that's all I needed. Now I can prove it to the court what she's doing. So when she eventually got a lawyer, and she's like, how are you going to prove it? I was like, I have an email from your client specifically mentioning I'm not legally married in Ontario. And that's the argument we're making. So she agreed to it, and eventually it worked out. So, just to go with the story to tell you that yes, it would change your the quantum of support that you should get once you get into another relationship that is of some permanence.
Yeah, great, Ayaz. So, thanks for bringing a lot of aspects on the support as well as the custody, the modifications that you mentioned for the custody, and also the rule of 65. Let's try to try to understand on the some common challenges that the individuals face when dealing with the family legal matters, and how can they be addressed. And also, we wanted to understand on the alternative dispute resolution methods that are available for the families going through the legal issues.
Sure. So one of the biggest aspect is that we're really expensive. Okay, so private lawyers, private practice is lucrative. Uh, there's so much research done in Ontario, at least that I can speak of, that about 90% of the family litigation pie, people are self-represented because they cannot represent, they can't afford proper legal help. Uh, is that something that I've created? Maybe not. It's been generations in the making. I'm just another cog in the system. Am I perpetuating it? I'll be honest, maybe I am. Uh, you know, I don't decide the market rates, but that's one of the biggest challenges I would say that families face when they're going through a separation is proper legal help, because private practice, you'll find lawyers in the Greater Toronto area that bill anywhere from, I would say, $250 an hour up to maybe $800 an hour, plus HST, the tax. So that really adds up. That's the first concern. Second is, the good thing is the help that they have from the system is legal aid. There is legal aid available for family as well as criminal matters. But I have actually personally, not in my career, never done legal aid work. I never had to. I guess, fingers crossed, I never had to, because wherever I went, there was good private practice now in my own firm. But I would say this, that from what I hear, the income criteria to be met for legal aid is, that threshold is so low or high, and it's very hard for people to meet that. But don't get me wrong, there's a lot of legal aid work out there as well. So those are, I would say, that's one of the biggest challenges that people face. Apart from that, you know, apart from that, I would say that once they go into court and they are self-represented, that further, drags the matters in court, and there's a huge backlog. We're dealing with quite a big backlog, and trust me, yes, our backlogs are nothing compared to what it is in India. Don't get me wrong. If ours is one on a scale from 1 to 10, 10 being the worst. If we're one, I get it. Maybe India is 10, but again, you're 1.5 billion people or 2 billion people. We are barely 40 million. So I appreciate that. But again, systematically, that's a backlog that we've never faced, and COVID has a lot to do with it. But we're getting through it. We're trying our best. But I think those are the main issues that people would face getting into family cases. So, Siraj, what else can I answer for you?
Yes, so probably we would also try to understand a bit of the intersection of the criminal and family law, and how are the criminal and the family courts different in Canada, and the legal aid in the case of such kind of cases where there is an intersection in between the family and the criminal subjects.
Very good question. Actually, the reason why I got into criminal law practice is because of family, because a lot of times one of the spouse would get the other charged for some kind of domestic assault. I'm not saying that all of them are false, but quite a few of those cases are false. And this is just to get a leg up or have them kicked out of the house or try to get a better deal in the child custody. Not recommended, but a lot of people do it. I'm sure I wouldn't say that the lawyers recommend that people should do it. I think people just do it. Sometimes there are genuine cases. I'm not saying there are none, but it happens. What's the difference between the courts? Well, the standard of proof. That's the biggest question. It's the standard of proof. In criminal law, it's beyond reasonable doubt. In family or civil law, it's balance of probabilities. That's the biggest difference. The other difference is in family law, when you lose, you may very well just lose some money, or maybe your kids for that matter, which is nothing, not nothing. Whereas in criminal law, your liberty is at stake. So yes, there's legal aid available for both of them. Certainly for criminal law, if the crown is essentially the government attorney, because in Canada, crimes are not committed against people; they're committed against the state. I don't know if that's the same in India as well. Well, you
Yes, of
guys
course.
follow the Thomas Macaulay wrote the Indian Penal Code, right? So yeah, it would be the same. I've actually done quite a bit of research on Mr. Macaulay, so I know that much. So I'm sure there's some changes, but they're still using the same penal code written by him. So I get it. That's probably the intersection there. Yes, we do have a timeline when it comes to criminal law matters. There was quite a few years ago, there was a case that went to Supreme Court because part of the charter is that 11B of the charter says that you must be tried within a reasonable amount of time. That's that's a basic freedom or a right that you're provided as a Canadian. So that means there was a case that went to Supreme Court. It's called the Jordan case, where there's timelines set, which is essentially if you're in the lower court, Imperial Court of Justice, your matter must be done. Well, you must be at trial from the date of arrest within 18 months. And in the Superior Court, I believe it's 24 months. I could be wrong about it. A lot of my cases are tried in the Ontario Court of Justice. So the idea is that the Crown must give you the evidence, do all the preliminary matters, and most likely give you a trial date and do the trial within that amount of time. Once that amount of time is gone, your defense counsel has a right to bring an 11B application. And if you are successful, if you can prove the delays on the Crown, your charges are not withdrawn, they're stayed. So it's essentially that the effect is this. Well, effect is the same, but there's still to an extent they may stay on your record. It doesn't say you're a criminal, but it says the charges were stayed. They were not withdrawn, and happens quite often than you would believe, and has been happening quite a bit since the COVID pandemic because of the delays. So that is what I would say, Siraj. Uh, Unless there's anything else.
Absolutely. I think like there are definitely multiple concepts that we have kind of, discussed today, and this is growing more and more interestful. And I should admit that this is quite insightful as such for us and the audience. Nevertheless, time matters. So this kind of brings us to the end of the conversation for today, Ayaz. Thanks for helping us and our audience understand the various aspects of family laws in Canada, especially bringing the aspects of the provisions of the divorce, and as well as the importance of the child as well as the spousal support in the custody aspects, and the intersection of the criminal as well as the family section. So we once again thanks a lot from Advotalks.
Thank you for having me, and I hope none of you ever have to use my services. You have yourself a wonderful day. Take care.
Thanks a lot. So that's about today's episode with Counsel Ayaz Mehdi, which brings a lot of insights on family laws in Canada, where we understand the provisions for divorce as well as the custody as well as the support for spouse as well as the children, and the intersection of the criminal law and the family law. So we hope uh, the conversation has been knowledgeable. For more updates and information on legal concepts, please visit our website www.advotalks.com, and don't forget to like, share, and subscribe to our YouTube channel, Advotalks.